Welcome to Nguyen Do Lawyers channel. For decades, a stack of glowing reference letters from a boss or footy coach could reduce a prison sentence. That practice has now been abolished. Following an announcement in February 2026, the Victorian Government is removing good character as a mitigating factor in sentencing. Under the traditional system, defense teams used a clean criminal record and community standing to argue that a crime was merely an isolated mistake. While this was a standard defense strategy, it often functioned as a shield for the privileged, allowing their social status to outweigh the severity of their actions. The shift was triggered by cases where high-status individuals successfully used their social capital to secure more lenient sentences for serious offenses. For victims of crimes like rape and assault, the sentencing process often compounded their trauma. They were forced to listen as community leaders praised the character of the person who harmed them. This legislation changes the focus. The justice system will now penalize offenders based on their conduct rather than their professional networks. This recalibrates the court's priorities, placing the denunciation of the crime above the preservation of an offender's reputation. Not everyone agrees with this new change. The Australian Lawyers Alliance has warned that a total ban may be too broad. Sentencing is usually built on individualized justice, the idea that a judge must assess every person's specific context. A blanket ban creates a rigid filter that prevents the court from seeing the offender as a whole person. This risks disproportionately affecting our marginalized defendants. These individuals often rely on community letters to prove they are actively working to turn their lives around. In the attempt to stop elite offenders from leveraging their status, the law may accidentally remove the necessary context for the most vulnerable people in the system. This is part of a national trend. New South Wales has already implemented an across-the-board ban on character references. In Victoria, the new laws are scheduled to be introduced to Parliament in the middle of 2026. Anyone facing court in late 2026 or early 2027 will likely be subject to these new, stricter requirements. The window to use traditional character defenses is closing, leaving those who are unprepared highly exposed. Defense teams are now forced to change how they approach sentencing. Simply claiming a client is a good person is now legally irrelevant. To argue for a lighter sentence, the focus has shifted to dynamic risk factors. These are clinical metrics that track an individual's rehabilitation and their actual risk to the community. Instead of personal letters, courts will now require professional psychological reports, social worker evaluations, and structured rehabilitation plans. The courtroom focus has moved to proving treatment engagement and lowering the mathematical likelihood of someone reoffending. Successfully navigating a sentencing hearing now requires clinical proof of change rather than a reliance on who the offender used to be. Entering a courtroom in 2026 or 2027 with outdated advice and a stack of character references could cost a defendant their freedom. A successful defense now requires an understanding of how to build a clinical, risk-based argument from day one. Follow Nguyen Do Lawyers channel for updates on major law changes in Australia. This is general legal information only and not legal advice. If you are facing sentencing, seek independent legal advice. The rules of the justice system have changed. Choosing a defense team that understands this new landscape is the only viable path forward.